Hello, welcome to Legal Action. My name is David Siegel. Today we're going to be talking about divorce and family law, and we're going to be dealing with questions that we received over the last several months from the viewers. I want to welcome Jesse Barrientos, my co-host. Jesse, how are you doing today?
Really good. How about yourself, David?
I'm doing well. And Jesse, you are going to take the brunt of these questions.
Oh, thank you very much, Dave.
You're going to throw them at They're going to throw them at you because you are the divorce and family law practitioner for over 21 years, handling cases in DuPage County, Will County, Cook County, and actually all the suburban counties, including Cook, correct?
That's correct.
All right. Well, let's fire it off. We're going to start with Amy in Long Grove,
Okay.
who wants to know how much, in terms of price, is the divorce going to cost me? It's kind of an open-ended question, I know, but
it is.
It gets asked all the time, and Amy has done so.
Well, I can tell if Amy were in my office, what I would tell her, of course, I would be able to ask her some more questions, but it really depends upon the specifics. For example, are the parties in agreement on all of the issues? Because if they are, it gives me a great idea, and I could probably get a whole lot closer to what a price might be. Is it contested? Meaning, are there areas that they're not in agreement? Does it involve child custody? Are they going to fight over who's going to have physical possession or residential custody of the children? And so it really matters, any one of those things. So if it's a custody case, it's probably going to be on the higher end, and there's no telling how that's going to go. We've talked on our show before in terms of custody, what's involved. A lot of times people will go to mediation. That's the first step because there's a lot of local rules that require it. If not, and the parties have the resources, either party or the court can, or either party can request or the court can appoint a GAL, a guardian ad litem, which is an attorney that looks after the best interest of the children, and the parties are going to have to pay, depending upon their resources for that person. They could get a 604B expert, which refers to the section in the Illinois Marriage and Dissolution of Marriage Act, which is a custody expert. They'll evaluate all the parties, they'll do psychological tests, and they'll make a recommendation that's based upon their experience and expertise and what they've observed and everything else, and they cost a lot of money. So it really kind of depends. I mean, this is going to be a really huge range. I mean, it could be anywhere between $2,500 all the way on up to $30,000, $40,000, $50,000 if custody is involved. So it is an open-ended question. I would need to know more specifically. But I will tell you this, if the parties are in agreement, that's the best route to go, because not only is it going to cost less, but you are going to have control over the final judgment. Otherwise, you're going to have some judge, wherever it's going to be, listen to a thumbnail sketch of your life and the issues, and the judge is going to make a determination that both parties are going to have to live with, period. So, if you can agree, that's the best way to go. That's the best I can do for Amy. Was it on this question?
Yeah. Okay, sticking with the financial theme here, we have Larry from Joliet, who wants to know, if my spouse and I are both working, will I be required to pay child support? Again, it's a money issue here that always comes up.
Sure.
Do they have to pay child support if both spouses are working?
Well, again, that's a little bit of an open-ended question. Are both parties still living in the same house? Because if they are, and that happens quite often these days, especially with our our real estate issues that everybody's having, and people can't afford it. And a lot of times divorce is really dividing up the pie, getting rid of the assets and splitting the liabilities. And if neither party is going to buy the other person out, a lot of times, if they can, doesn't happen in every case, but they'll stay in the same house and put it up for sale. And during that time, both parties are going to be required generally, and again, that's also depends on the specifics, to pay the mortgage, to pay the utilities, to pay the bills, buy the groceries and all that. And if that's happening, there's really no need for child support because those needs are being met. Now,
what if they're not living together?
If they're not living
two
together,
separate households, even though they're not divorced yet.
Right.
What happens then?
If they're in two separate households, the person who has physical or residential custody of the children, that's possession of them most of the time, that's the residential parent. The other parent is still going to have to pay child support. And the Illinois Marriage and Dissolution of Marriage Act has kind of guidelines in terms of what that is. For example, for one child, it's 20%, for two children, 28%. And it kind of goes up from there, and that's of your net income, which is defined in the statute as well. So, yes, you will have to pay, in that situation, two households, you will have to pay child support. Here's something that is very important for people to know too. It is your child. You have an obligation.
Or is it?
To take care of your child. Well,
or is it? That's another issue.
Well, Dave, there's a presumption if the child is born during the course of the marriage that it's a marriage of the child. It's a legitimate child. We don't blame children for.
We've seen cases though where someone is paying child support for over a decade.
That's correct.
Only to learn that they're not the biological father. And in those cases, you have to continue to pay that support.
You have to pay it. I mean, that we could do a whole show, I think, on that. But generally, yeah, you're going to have to pay that support if you're in a household. Here's something that people ask all the time too, and it's kind of on point, so we can talk about it. A lot of times, people want an itemization, an accounting, if you will, of those specific dollars that I give to my spouse or my ex or whatever. Well, hey, listen, you know what? I want to see what you bought with it. Is it Pampers? Is it food? Well, wait a minute. We have an infant. He can't eat steak or fish or anything. And so it doesn't work that way. Child support is for the support of the child, and it covers a roof over his or her or their heads. It covers utilities. It covers food. All those kind of things. So you can't really, boy, it would be a much more complicated world, and I think we'd be a whole lot busier if there wasn't accounting, and there shouldn't be, to what the child support is. So I guess in the case where they're living in two separate households, yes, unless the one person isn't working, but that's the question says that they are.
Right. Sarah in Ivanhoe, which is up in Lake County, wants to know if she is entitled to her spouse's inheritance/trust fund.
The short answer is no.
Why not?
Generally, and again, this is generally, and I want to caution everybody that what you really need to do, what our viewers need to do, is to go and to speak with somebody who does domestic relations, somebody who does a lot of that and who's competent in that, because each situation is different. So generally, what happens is that anything acquired during the course of the marriage is marital property, or any kind of debt's marital debt. Now, anything that you have before the marriage is yours. Okay. So if I have an inheritance or a trust fund, even if I got it during the marriage.
Well, that's what happened here.
Right. And the
inheritance was acquired during the marriage.
And I just leave it, and I don't commingle it.
No, they commingled it. They put it in a joint account that they both use for bills.
If they put it in a joint account, then the answer would be she may. I know, it's not what you want to hear. She may be entitled to it. Because once you commingle it, there's a couple of different things you have to get over. There's a presumption of a gift because I'm kind of giving it to you. I mean, there's a whole bunch of reasons why people put things together. And so if it's together in a joint account, then she may be entitled to it. If it wasn't put in a joint account, and I don't think that's what the question said, Dave. I think you're giving me a hard time here. But if not,
I'm
then
testing
no.
your knowledge.
Oh, okay, I appreciate that. But
and I know you can do it.
If it wasn't commingled in a joint account, probably she wouldn't be entitled to it. If it was, she may be. But there are, again, some very specifics that we need to know.
Okay, what about lottery earnings acquired during the marriage? Husband bought the ticket. Wife never plays. She's against it. She swears against it, has never played. All of a sudden, though, husband won.
Well, I can tell you because there's a couple of answers to that, too. Remember what I said a little earlier. All assets acquired in the course of marriage is marital. However, if I were maybe representing the husband and we determined that the money that he used to buy the ticket came from non-marital funds, that might be a different story. Now, in order to prove that is a whole nother question. So, but if the whole thing is when you get married, it's one estate. It says in the Bible, right, that two become one. It's one estate. So anything that I get is ours. Anything that you get is ours. It's one estate. And so, that's, if I buy something from monies, even though I'm working and I'm making it and she's staying home. It's our monies. It's one estate. It is marital monies. Let's take the example of a trust fund that wasn't commingled, right? Let's say that I bought the lottery ticket with that dollar that I got from that trust fund, and I can prove that. Well, hey, then it's non-marital monies that won the the lottery. And so, but I really can't see a judge. You really have to prove it, and there's just no telling what the judge would do, depending upon where you're at.
That's true. Kind of along the same theme, Gerald from Homewood wants to know, is my spouse entitled to any of my pension? Because he earned that pension during the marriage. His spouse didn't work, and now there seems to be an issue on whether or not she's entitled to any of it. So he wants to know that.
Gerald, I have some good news and some bad news for you. Let's start with the bad news first, because that's always better. Yes, your spouse is entitled to at least 50% of the marital portion. Now, what I mean by the marital portion is the amount of pension that was acquired during the course of the marriage. Let's say I worked for 20 years at the railroad and I have a pension, and now I got married and I'm married for 5 or 10 years. My spouse would not be entitled to the 20 years of pension that I acquired before I got married. That's premarital. That's going to be mine. And that's why they say the marital portion. So the 10 years that we were together, that marital portion she'd be entitled to. Now, I say 50%. That's just kind of a generality. That's kind of what happens, and that depends upon the situation. Sometimes the judge will order a different percentage. He may, or he or she, the judge may award the other spouse 50%, 60, 70, 30, 20. It just depends on the specific situation and the assets and everything else that the parties have.
Okay.
You know what? I want to address one thing real quick.
Sure.
To go back to the trust fund issue.
Mm-hmm.
Now, even though that person wouldn't get it, wouldn't have to share it with the spouse if it was not commingled. What would happen though is the courts are entitled in the distribution, the apportionment of property in a divorce to consider the party's non-marital property. So let's say our marital estate, we have a house and $100,000, and my non-marital, my trust fund, my inheritance, I have $20 million. Well, the likelihood is that in the divorce, my spouse is probably going to get the lion's share of whatever that is. And again, I just wanted to point that out because that's a little subtlety there.
Okay, this comes from Natasha in Palos Hills, once again regarding child support. How do I get my spouse to pay child support when he works on commission and gets paid in cash as well?
Well, we got two problems here. Let's just deal with the commission. Let's just say someone's making a commission and you can't tell. Well, there are child support. There's a uniform child support order that's pretty much stratified throughout all of our jurisdictions here, and it has the same information and everything else. It might look a little different, but everything generally is the same. And so we talked earlier about there being a percentage, the guideline percentage of child support based upon how many children you have. Again, 20% for one child, 28% for two, and so on. But again, that's just a guideline. You could deviate upward or downward, and we could talk about that at some point. But so you could do either, right?
Right.
Either one of those things. But they also have a percentage order for just this type of situation. So basically, let's say there's one child in the marriage. They could do a percentage, so 20% for the one child of whatever that person makes. There's a lot of different ways to do it. Let's say the person makes a base salary and has a commission. Well, we can figure out what the base child support is, but then we would have some type of provision that indicates that, hey, listen, anything over that base, he'd have to pay the appropriate amount, in this example, 20%, within 30 days or whatever of receiving it. Now, the other part of the question, I believe you said he was self-employed or he was receiving
Paid in cash.
If he's paid in cash, that's a really tough deal. And you see that with a lot of people that are self-employed, or, for example, let's just take a landscaper, someone who does landscaping or maybe who plows the snow in the wintertime. It's cash. What do you do with something like that? Well, it's not impossible. What is required, or what you need to do, is just to track it down. Now, unfortunately, a lot of times it's going to require some resources on your part to be able to hire perhaps a private investigator to kind of look at things. That's one avenue. The other way is if the person has a list of clients that he goes to, that's the better, you still have to roll up your sleeves and do some work, but you get the list of people, you find out what that person's been paying for their work, and you go from there. I mean, that's more tedious and it's more difficult. And, it's cash. You can't account for every single cash dollar that really somebody gets.
Okay. Jim from Chicago wants to know, am I responsible for my spouse's debt? Specifically credit cards.
Yeah,
A lot of times parties have separate credit cards.
Sure.
Even though some of it's used for marital purposes, some often is not.
Well, if it's credit card debt that was incurred before the marriage, then no, generally. If it was incurred during the course of marriage, most likely yes. However, remember we were talking earlier about the marital estate. Everything is this one thing. Now, let's say that I used or she used the credit card to buy her, take her boyfriend on vacation or do something else. That's what we call dissipation. And, he may not be liable for that type of debt. But if the credit cards were used for any marital purpose, for food, for going out together, for clothes, those kind of things, to pay bills, a lot of people rob Peter to pay Paul all the time, especially in this economy, then again, all debt acquired during the course of the marriage is marital debt generally.
What if you can't prove dissipation? What if it was a cash advance that one spouse says was used on a frolic with a boyfriend or girlfriend, and the other spouse is saying, no, I used it for food, clothing, gas for the car?
Well, I tell you, you got to trace it, and the party that brings dissipation issue.
He who alleges must prove.
Well, no, not in this
No?
particular case, because if I bring up dissipation, then it's incumbent upon the person that I'm accusing of dissipation to prove it. And that makes sense. It makes sense because I would never be able to have the documents to be able to show it, but that person would. So to be able to show that it's not dissipation. So that makes kind of sense there, that it would be incumbent upon that person to show the dissipation. So once I allege dissipation, that the other person is committed dissipation, then it's incumbent upon them to provide the trail that it is not.
Okay. Andy from Naperville, DuPage County once again.
Okay.
How long until the divorce is final?
This is what I love. There's a lot of questions, and I can't give an exact answer. I will tell you. Let's take a couple things. Let's say the parties are in agreement, and generally and we call those uncontested matters. Generally, what we do with those, if they're in agreement, we see what they're in agreement on. We draft everything up. Now, understand, in a divorce, an attorney can only represent one party, can't represent both interests. And a lot of times people do come in together sometimes even, and it has to be explained to the other person that, hey, listen, I don't represent your interest, I represent her interest, or vice versa, or whatever the case may be, so that there's no confusion that, our attorney is representing both of us in divorce. No, it doesn't happen. So if it's uncontested, we draft everything up all together, everything gets filed at the same time, and in that case, it could probably be over, and we call that the prove-up. That's where you prove up the divorce, the allegations of your petition for dissolution of marriage, within about 30 days. Some counties have a rule, and I believe Will County is one of them, where if you file it, even if we're all in agreement, we have all the papers, all the docs ready, and we file it, we have to wait 30 days before we can actually do the prove-up.
What's the theory behind that? What's the reason for this 30-day waiting period, even though both parties have agreed to go forward?
In Will County, I'm not so sure what the thinking is.
Biblical.
Biblical, a chance for reconciliation.
Yes.
So, if you
A
look at it
statement
that way.
against divorce.
Right. But, realistically, in my office, when people come in, that's one of the questions that we explore. We go through everything so people are informed, and it's important for people to know what's going on so that they can make an intelligent, informed decision. So I don't sugarcoat anything. I don't tell you what you want to hear, because that's not what you're coming to me for.
Well, Andy still wants to hear, when is it final?
Well, in that case, it would be final possibly within 30 days. If it's contested and the parties don't agree, it could last between a year year and a half, 2 years, 3 years. It just all depends upon what's being litigated. There's a Supreme Court rule with 180 days, a year and a half, you have to have the custody disputes resolved, which is separate than the rest of the divorce.
3 years, you can get a law degree.
That's true.
Okay. But is it ever really final? This is kind of a trick question. Is it ever really final, Jesse?
Well, it's final in the sense that the bounds of matrimony that put you together are now torn asunder. You're divorced.
And you can't come back to court for anything?
We're no longer married. No, you can. So it's final in that respect. But realistically, especially if you have children, you're going to be in each other's life for a long time, well beyond the child's 18th birthday. You're going to be there for college graduation. You're going to be there for their marriages and everything else. And
so if your ex-spouse is angry and they want to bring you back in to increase child support, to decrease visitation, to open up some can of worms about some type of asset that might not have been disclosed in your schedules, you're in court continuously.
You are, but it doesn't have to be because somebody's angry. It could be because the situations have changed, and now, instead of me getting my 20% for child support, now you're earning 5 times as much as you did when we got, divorced. And so what that means is that, hey, the children are expected to share in the wealth of either parent. And that's your child, and you have an obligation, and you should. We get a lot of issues with people contributing to, college education. It's your child. And that's interesting because the children of divorced parents, they have to contribute to their college education. But if your parents aren't divorced, there's no such right.
That's true. Okay. People are afraid of court, some people.
Yeah.
I know someone who was arrested in one county. He won't even go into that county again for anything. So there's a fear of the court system.
I think I know which county that is. I'm not going to say, though.
That's right. So Joey in Mettawa wants to know, do we both need to appear in court?
No. Well, you do if there's a trial.
What percentage of divorce cases go to a trial?
Well, I'm not sure about the exact percentage, but I can tell you that the majority, the overwhelming majority, kind of, end up settling it. Once you go through and you do what they call discovery, you find out what everybody has and everybody presumably has disclosed, then you'll take care of it. But generally, the petitioner, the person who filed the petition for dissolution of marriage, is the one who has to prove up the divorce. That person has to appear. If there's a marriage settlement agreement that's already been agreed to and signed by both parties, then it's only the petitioner that has to appear in court.
Yeah, and that's not dissimilar from a real estate transaction that you can kind of sign the documents in advance and let it get presented by somebody else, correct?
You could do that, or in that case, you could, do a power of attorney for your attorney to sign off on whatever docs.
Okay. Critical question here, very important.
Sure.
Maureen in Deerfield wants to know, will my child have to appear in court if there's a custody battle? They want to protect the child.
Well, and again, this is one of those things where it's a maybe answer. It depends on how old the child is.
This child's 6.
The child's 6
Very
years
young.
old. Very young. Well,
not tender years, doctrine, but
right.
very young.
The court can do what they call an in-camera review of the child, which means that the child goes back into chambers and speaks with the judge. And now the judge can decline, either party can request that, but the court can decline to do that. And there are some other rules too. Both attorneys, unless they agree, have to be present, and there has to be a transcript of that.
I don't see a lot of judges taking that much interest in the cases.
Well, I've had a couple cases where there were exactly that, in camera inspections, or interviews with the child, and the judge is more informal. So they take off their robes, and they're not on the bench. They come down and even sometimes sit on the floor with the child. Yeah, and just to make them kind of feel at home. But realistically, you've got mom's attorney there, you got dad's attorney there, and it's difficult sometimes for the child. But that's just one aspect. That's just one factor in determining custody, is the wishes of the child. Now, the younger the child is, obviously, if it were an infant, there's, child can't express his preference. But generally, the older the child, the more weight is given to the child's wishes. Because I hear a lot of people say, well, isn't 13 the magic number where if they want to live with me now and they live with mom, then they can live with me? It doesn't work that way. The kid could do that, but that's just what the child
18 is the
wants.
magic number.
Well, 18, then he's a man, so he could live, he can live by himself, or she can live by herself if they want. But so I guess the long story and short is that it really depends upon the specifics of it. Now, remember earlier we were talking about a guardian ad litem, who is a person, an attorney who looks after the best interest of the child, and a 604B expert, which is a psychologist. The child in a custody battle, if any of those things are engaged, will speak to the evaluator and talk, and the evaluator will relate things. Same with the guardian ad litem. So it's more informal. I'm a guardian ad litem as well, and a lot of times, we meet at mom's house, we meet at dad's house, with mom, without mom, with dad, without dad, sometimes in the office, just so that they're not present. So you don't want to put, you don't want the parent to be there. Sometimes you do because you want to see that interaction. But in those instances, generally, the child probably will not testify. That's more of a rarity.
Okay, well, that's reassuring for her. Allison in Park City, once again, Lake County. Can I force my husband to leave our residence once I file the petition for dissolution? So right from the start of the case, can the spouse be removed?
Yes. There's a couple ways, and this really disturbs me. Too, we have the Illinois Domestic Violence Act, and that's where we have orders of protection. Orders of protection very often, too often, are used as a precursor to a divorce. So the feeling is, once I get him out, now I'm in control. I have the kids, they're with me because he can't see the kids, or she can't see the kids, as the case may be, and it gives me a leg up in the divorce. And so they'll go in, pro se means by themselves, depending upon the situation, and get an order of protection and oust that person for 21 days. 21 days is when they set the hearing. Now, under the Illinois Domestic Violence Act, you can, by a couple days' notice here, notify the other person and have your hearing kind of moved up.
Expedited.
Expedited, exactly. And those kind of take priority. So that's one way to do it. Now, there might be a legitimate reason for an order of protection.
I think expediting it is a great way to basically say to the court, this was a bogus complaint against me, and I want it addressed now.
That's true, but you need to, this is what I kind of see. I think the judges err on the side of the children, and that may be the way that it has to be, I don't know. But if there's any question, I think they give them the benefit and they'll grant the order of protection. But there might be a legitimate reason for it. It depends on why you're getting the order of protection. What did you do? Did you push Johnny down? Did you slap him? I mean, did you choke me and try to restrain me from calling the police or leaving the house? Those are legit. That's why it was designed. That's what it was designed for. Those type of things, not to get a leg up on an impending divorce. Okay. And the other way, though, too, within the divorce, forget about the order of protection. Say we file the divorce, there is a motion for exclusive possession. Now, you have to have some very good reasons for that. A good reason would be maybe there's a lot of tension between mom, dad, and the kids. And so, if you have that tension and it's not healthy, and a guardian ad litem or somebody, kind of makes the observation, says that. But there are other reasons, too, why you might want to get exclusive possession or reasons to allege.
All right, Jesse, thanks for addressing those concerns of our viewers. My name is David Siegel. We'll see you next time on Legal Action. Take care.